9 p.m., Monday, August 20th, 2012. Inside a private members club in London's Mayfair district, a professional poker player leans toward a dealer and asks her to turn a single card a certain way before it goes back into the shoe. Just a superstition, he tells her. She has no reason not to believe him. Less than 24 hours later, he'll be £7.7 million richer. He won't touch a single card to alter it. He won't lie to her directly. And by the account of every judge who examines this case over the next 5 years, he won't break a single written rule of the game. The casino will refuse to pay him anyway. What follows isn't a robbery. It's a legal war that ends at the highest court in the United Kingdom and quietly rewrites what the word dishonest means under English law. This is that story. Every casino runs on one idea, the edge, a mathematical certainty built into every table, small enough to go unnoticed, permanent enough that no skill can undo it. Crockfords Club in Mayfair had operated on that certainty since 1828, outlasting wars, recessions, and changes of ownership without ever questioning the arithmetic underneath its tables. Borgata Hotel Casino in Atlantic City had built a modern empire on the same premise, with one of the busiest, most profitable gaming floors on the East Coast, competing for the same high-limit players who move between Las Vegas, London, and Macau. Neither casino worried about genius. A brilliant poker player can outthink another person, adding a bluff, a hesitation, or a tell. He cannot outthink a shuffled deck. That distinction, skill against a person versus chance against the house, was the quiet assumption underneath every high-stakes table in both buildings. Regulators built entire legal frameworks around it. This is the story of the case that dismantled that assumption, not through force or deception in the way either casino first understood it, but through something closer to observation. By the time either institution realized what had happened, tens of millions of dollars had already left their vaults, paid out willingly, recorded as legitimate winnings, signed off by dealers, pit bosses, and accountants who had no reason to think otherwise. Nobody would ever dispute that the money moved. What courts in two countries would spend the next 5 years disagreeing about, sometimes with each other, sometimes with themselves, was whether anyone had actually broken a rule to move it. It began with something almost too small to matter. Playing cards manufactured by Giamaco, used at both Crockfords and Borgata, carried a printing pattern on their reverse sides that wasn't quite symmetrical. On certain cards, a diamond motif ran a fraction closer to one edge than the other, a gap measured in millimeters, invisible at a glance, and meaningless to anyone who didn't know exactly what to look for. Phil Ivey, one of the finest poker players of his generation, partnered with a professional gambler named Chung Yin-soon, known as Kelly-sun, nicknamed the Queen of Sorts for her specialty, spotting defects in card printing. Their target was Punto Banco, a Baccarat variant built almost entirely on pure chance, where players simply bet on which hand lands closer to 9. Sun had noticed something the rulebook never specified. Nothing says which direction a card has to face once it's shuffled back into the shoe. So she asked, framed as superstition, for certain high-value cards to be turned a particular way before they went back into play. The dealers obliged nothing about the request that touched a posted rule or a single instruction from compliance. Card after card, session after session, the asymmetry stopped being meaningless. It became a code, visible only to 2 people at the table, built entirely from small gestures by staff who had no idea what they were actually doing. Nothing was marked. Nothing was switched. The only real question, one that would take 5 years and 2 legal systems to answer, was whether reading a defect the manufacturer put there counted as interference, or simply advantage taking within the rules, exactly as written. The technique was tested first in Atlantic City, months before London entered the picture. Borgata's high-limit room operates almost as a separate world within the building, reserved for players trusted with significant credit lines and privacy far beyond an ordinary floor. Exactly the kind of room where a repeat player can make the same small requests, session after session, without anyone thinking twice. April 11th, 2012, Ivey and Son win $2,416,000. May 3rd, another $1,597,400. July 17th, their largest single session, $4,787,700. A fourth visit brings in $824,900 more, at one point with the pair reportedly up by roughly $3 million before the numbers settle lower. 4 visits, around $9.6 million net, moved through Borgata's standard high-limit payout channels, a figure that would resurface, almost unchanged, in a federal courtroom 4 years later. What's easy to miss is how unremarkable all 4 wins looked at the time. No dispute at the table, no flag in the surveillance review. By every internal standard Borgata had in place, these were 4 clean, verified wins by a player operating within the house's own rules. In the moment, with full access to the table, the dealers, and hours of footage, Borgata's own trained staff called these sessions legitimate 4 times across 3 months. No memo raised a concern. No procedure changed. It would take a second version of the same story, playing out on a different continent, before anyone circled back and asked the obvious question. Until then, the money simply moved 4 times, quietly, from Borgata's vault into 2 players' hands. Between the Borgata sessions, Ivey and Son crossed the Atlantic. Crockfords isn't built like Borgata, a private members club, not a public floor, catering to exactly the high-limit international player Ivey represented. In August 2012, they sat down to play Punto Banco under conditions meant to mirror what had already worked in Atlantic City. It did not start the way they wanted. Ivey deposited roughly £1 million to play, and the early hands went against him. His stack shrank noticeably before anything turned around, a detail the Yenting's lawyers would later use to argue the outcome had nothing to do with chance working against him. But the same quiet requests that had worked at Borgata started again, the same superstition, the same casual instruction to a dealer about which way to turn a card, and gradually, then not gradually at all, the shoe became readable. What happened next unfolded across a single, extended overnight session, hand after hand, hour after hour. There was no single dramatic moment where the tide visibly turned. There was only the slow, compounding weight of a system, reading itself correctly, over and over, until a man who had started the night nearly £1 million down was, by the early morning, ahead by £7.7 million, one of the largest single wins in the club's nearly 200-year history. Crockfords did what casinos do when a win is real. They issued him a receipt, standard practice pending final processing for a payout at that scale. That processing never finished the way it had in Atlantic City. Someone inside Yenting's compliance division went back through the session footage and noticed what nobody at Borgata had thought twice about. The same repeated card rotation requests, session after session. This time, nobody called it superstition. They gave it a name, a technique, documented and repeatable, TE, and once it had a name, the entire night was read differently, not as a win, as something the casino would soon formally call cheating. Yenting withheld the full £7.7 million. Ivey got back only the £1 million he'd walked in with. Nothing more. No partial settlement. No negotiated middle ground. And the position, once set, never moved. Not once. Across 5 years of litigation in 2 different countries. In May 2013, Ivey went public with his side of it. He'd been handed a receipt, he said. a physical written acknowledgement of a win, and Crockfords had withheld payment regardless, leaving him with no option but to take the club to court. Genting's answer, for its part, never wavered either, across 3 separate court rulings over the following 4 years. The club had acted properly, full stop, and what Ivey had done met the legal definition of cheating regardless of whether he'd personally set out to deceive anyone. 2 accounts of the same 9 hours. In one, a supremely skilled advantage player, spotting and using a manufacturing flaw entirely within the rules as they were actually written. In the other, a calculated manipulation of casino staff, engineered specifically to defeat the randomness that the entire game and the entire industry built around it depended on. What's notable is what this case wasn't. No criminal complaint was ever filed by either side in either country at any point across 5 years. This was, from its very first day in court, a civil and contractual dispute, not a case about theft or fraud in the criminal sense, but a much narrower, stranger question. Does money legitimately won under a game's written rules still have to be paid if the method used to win it breaks the game's unwritten premise that the outcome was never supposed to be readable in the first place? That question alone would take 5 years, 3 courts, and 2 legal systems to even begin to answer. By late 2014, the dispute was no longer one story. It was 2, running in parallel on opposite sides of the Atlantic, inside 2 legal systems that had almost nothing in common with each other. In London, Ivey sued Genting directly for the withheld £7.7 million. The High Court ruled first, and its reasoning was, on its face, an odd one to sit with. Judge John Midding accepted, as a matter of established fact, that Ivey genuinely did not consider what he'd done to be cheating, and ruled against him regardless, finding that cheating had occurred, whether Ivey believed it or not, and that the underlying obligation to pay him was void as a result. Ivey appealed. On November 3rd, 2016, the Court of Appeal upheld that ruling, but only narrowly, 2 judges to 1. The majority held that dishonesty simply isn't a required ingredient of cheating under the relevant section of UK gambling law. Interfering with how a game unfolds can be cheating on its own, with no intent to deceive required at all. The dissenting voice, Lady Justice Sharp, pushed back hard, arguing the lower court had misread what cheating requires in the first place, and that nothing about Ivey's conduct had actually been dishonest, a split serious enough on a question important enough to justify one final appeal to the only court left above it. Meanwhile, in New Jersey, Borgata had filed a case of its own, seeking back the entire $9.6 million it had already paid Ivey and Son over 4 sessions, plus damages and legal costs that pushed the total demand past $10 million. In late 2016, a U.S. federal court ruled largely in Borgata's favor, ordering the winnings repaid in full, though the more serious racketeering and fraud allegations, the ones that could have tripled the total judgment, were dismissed outright. Separately, Borgata went after Yamaco, the card manufacturer, for $10 million of its own, arguing that a defective print run was the real root cause of losses its own dealers had unwittingly helped create. 2 courts, 2 continents, almost identical underlying facts, and, remarkably, the same practical outcome reached through 2 entirely different chains of legal reasoning. But the largest question of all, the one both rulings had sidestepped rather than answered: can something be legally dishonest with no actual intent to deceive anyone? Was still sitting open. The story had, by now, drawn the national press on both sides of the Atlantic. Ivey's career, notably, hadn't paused for any of it. In 2014, in the middle of the litigation, he won his 10th World Series of Poker bracelet. That final, unresolved question was too large for a trial court or an appeals panel to settle on its own. It would take the UK's highest court hearing a case like it for the first time in 35 years. In February 2017, the UK Supreme Court agreed to hear Ivey's case. That decision, on its own, told you something. The Supreme Court doesn't take every appeal that reaches it. It takes cases of what the law calls general public importance, disputes that end up mattering far beyond the two people arguing them. A 5-year-old Baccarat dispute had just been formally recognized as one of those. The hearing took place on July the 13th, 2017, in front of 5 justices, then nothing for over 3 months. Judgment reserved, while 5 of the most senior judges in the country worked through a question that had already split 2 lower courts. On October the 25th, 2017, the 5 justices ruled unanimously against Ivey. No dissent this time, not even one. The court's reasoning split cleanly into 2 separate questions the lower courts had blurred together for 3 years running. What does cheating actually mean under UK gambling law specifically? And, far more broadly, what does dishonesty mean under English law? In any context, in any case,
the security footage proves my innocence. Why won't
on
the
the
jury
first
look
question, the justices were direct.
Defense is aware that
Punto Banco's entire legal and commercial premise, they held, depends on cards being dealt in genuinely random, unmanipulated order, getting a dealer to orient cards in a way that destroys that randomness, even without a lie spoken aloud, even without a single card physically touched by the wrong hand, interferes with the game in exactly the way the law is entitled to call cheating. Lord Hughes, delivering the leading judgment, didn't hedge. He described what Ivey and Son had done as a carefully planned and executed sting. That would have been enough to decide the case. The court chose to go further. On the second question, the justices did something the case never technically required them to do. The existing legal test for dishonesty, known as the gauche test, used continuously in English courts since 1982, was, they ruled, fundamentally flawed. It had always asked 2 things. Was the conduct dishonest by ordinary standards? And did the person themselves realize that? That second question was the flaw. It lets someone's own distorted private sense of right and wrong function as a kind of shield, a defense built entirely out of what they personally believed about themselves. The court didn't need to fix that to rule on Ivey's case. They rewrote it anyway, turning a £7.7 million dispute over a card game into the vehicle for redefining a legal standard that every English criminal court had relied on for 35 years. For Ivey, there was nowhere left to appeal. The money stayed with Genting permanently. He'd later say the outcome made no sense to him. Every judge, at every level of the case, had separately agreed he wasn't personally dishonest, and he'd still lost. A contradiction he described as impossible to reconcile, and one that, by the letter of the ruling, he was simply never going to get to argue again. Genting's leadership called it complete vindication, a decision, their president said, that had never been taken lightly, and now, finally, didn't have to be defended a 4th time. Strip away the casino, the cards, and the £7.7 million. And here's what actually happened on October the 25th, 2017. English law quietly changed for everyone, not just gamblers. Before Ivey, every criminal and civil case in England that hinged on dishonesty ran through the gauche test established in 1982. It asked a jury 2 things. First, was this dishonest by the standards of ordinary, reasonable people? Second, did the defendant themselves realize that ordinary people would see it that way? That second question sounds fair on paper. In practice, it meant a defendant with a genuinely skewed sense of right and wrong could sometimes talk their way around conduct that everyone else in the room would call obviously dishonest. The Supreme Court's ruling in Ivey versus Genting casinos deleted that second question completely, for every case that would ever follow it, criminal or civil. What a person actually believed about the facts still matters. What stopped mattering was whether they personally recognized their own behavior as wrong. From that point forward, the law would ask only whether the conduct, given what the person believed at the time, was dishonest by one fixed, external standard, the judgment of ordinary decent people. Nothing more subjective than that. Legal commentators noticed almost immediately a civil dispute over a card game had just produced the first authoritative rewrite of the criminal test for dishonesty in 35 years, the kind of shift that normally takes an act of parliament, not a Baccarat lawsuit. Within 2 years, the England and Wales Court of Appeal made it official, applying the Ivey standard directly in a criminal case, R. v. Barton and Booth, a case with nothing to do with gambling, casinos, or a single deck of cards. Somewhere in a Mayfair casino, in a dispute over £7.7 million, the legal definition of a lie had just been rewritten for the entire country. Add it all up, and Ivey and Sons' total exposure between what Crockfords withheld and what Borgata clawed back landed somewhere between $19 million and $20 million. Borgata's case dragged on well past the Supreme Court ruling, further appeals, a court-ordered mediation, and finally, in 2020, a settlement whose financial terms were never made public. The Crockfords ruling, by contrast, was final the instant the Supreme Court delivered it. There's no court above it in that country on that question. There never will be. The technique itself outlived both cases. Chung Yin-sun later brought a separate lawsuit against Foxwoods Resort Casino in Connecticut, alleging that a matching printing defect had let her run the same method there, the same quiet request to dealers, the same manufacturing flaw hiding in plain sight, the same unresolved question now raised in a third jurisdiction with its own rules to interpret, which is really the point of all of it in the end. Years of case law later, the money isn't what's still unsettled. The money was resolved in full a long time ago. What's still genuinely open is the narrower, stranger question underneath it, whether a technique that breaks no written rule, deceives no one directly to their face, and requires nothing but a trained eye and a factory's printing error, can still, in the law's own final word, be called cheating. The UK's highest court answered that question exactly once, for exactly this case, and left the door open for it to be argued again the next time somebody finds a flaw nobody else noticed, which is, perhaps, the most honest thing anyone in this entire story ever did, because somewhere, right now, someone else is almost certainly looking at the back of a card a little more closely than they should.